I'm looking at the wrong thing. Yeah, September 13th. Well, at least I figured that much out. Civil Service meeting to order. First thing on our agenda is any public comments not related to an agenda item. And I need to turn my microphone on. Public here. No public comments. The second is the approval of the June 14th and 28th meeting minutes.
I make a motion to accept the meeting minutes as written.
I have a motion, a second. All in favor, say yes.
Yes.
Yes. Any opposed, no. Motion carries. I've only been on one appeal, and it's been a number of years ago, and it happened to be two policemen, the same case, and they were heard at the same time. That was my very first experience with a Civil Service Commission appeal. And that's been a few years, so I can benefit from this too. But at that time, our city attorney did give us a briefing on the procedures we can expect to see in the hearing. And our current city attorney has offered to do the same, and I appreciate her doing that, and I will turn it over to you.
All right, well, I appreciate that. My expertise in this area is somewhat limited in that I have read all of the state statutes and our ordinances, and I did Civil Service Commission hearings on behalf of the police and fire departments in Little Rock between 1998 and 2001. So it's been a minute since I've engaged in that process, but it's pretty similar, I think. That still, no really big changes since then. So we're going to go through and talk a little bit just about general things related to the Civil Service Commission, as well as the process for appeals hearings. So the statutes start out with the section noted there, and the Civil Service Commission itself is a creature of state statute, and the state statutes are specific down to how long you have to have lived in the city of Maumelle, and how many members we are to have unless we create an ordinance otherwise, and how you're to create your rules and all of those things. So pretty much everything that's in our own individual Civil Service Commission rules is straight from those statutes. Then we also have our own city ordinances that govern Civil Service Commission as well. So all the stuff we're going to talk about, pretty much all of it straight from the state or city code. The rules and regulations do set out definitions, how many of us there have to be to have a quorum, and the rules of order that we're supposed to follow, parliamentary procedure and all those things. And they tell us specifically what the subject matter is that the Civil Service Commission is supposed to deal with. Of course, we know the things that we deal with all the time. Eligibility lists, testing, and conditions. You guys are very familiar with that and how we handle that. Different classifications. We've made changes in that from time to time. And then, of course, personnel and disciplinary actions, which is what we're going to focus on today. So anytime there is a removal, suspension, and corrective actions, that's where there are certain appeal rights. Any suspension of 3 days or more is where the Civil Service Commission hearing process can come into play. The rules specify that whenever we're going to have a discharge, a suspension, a reduction in rank or rate of compensation, we're going to have, the chief is going to sit down with that person and give them a written notice. It's going to be in writing in a meeting, or sometimes they even do sort of a little hearing with them to explain why the reason for their disciplinary decision, so that they can have someone with them in that if they want to, but they can ask questions, they can make their statements to their chief, but then they have appeal rights to go ahead and take that and get a hearing with the Civil Service Commission. So once they get that written notice, they're going to have 10 days after they receive that to appeal to the Civil Service Commission, which, as we know, is what happened here. And that notice was provided pretty much immediately. And then we received some communication from the attorney later on. And then after that, we have 15 days to get the scheduling order out, which we've already done this time, setting out the date that we're going to have our hearing, and that sets up some dates for them to do discovery or request subpoenas, all of those pre-hearing procedures that they need to go through to get ready for the hearing. All right, so the role of the city attorney is a little different than in most city proceedings, in that I don't represent the police or fire department in these hearings. I represent you guys, and that's by state statute. There is a provision in the state statute that says that if you don't want me for whatever reason, you can hire another lawyer, so you do get that opportunity, just in case, you guys ever want to reach out and grab somebody else. But our city code specifies also that the city attorney represents the commission anytime we have an appeals hearing. Then I have a responsibility on an annual basis to put together basically a request for qualifications, which fortunately we had not done in a long time, but last year I did do. Just in the event we had a hearing come up, and the firm that we chose as part of that process is Greg Northern's law firm. So that explains why he is recusing for this hearing. All right, so both sides, they have, of course, to, adequate notice. Out of, we went back and forth. Anytime you're dealing with 5 individuals plus a couple of lawyers, we started out with like 12 dates, and we wound up with 1 that everyone could actually do. So we ended up with a good bit, a couple of months of notice for everybody, which is, I think, a good thing. They have to have at least, of course, 10 days notice, which there's really no way that you could do it in that short of a period of time anyway. They also can subpoena witnesses. So we will issue subpoenas to the witnesses that they give us on their list when they provide us that information. All right, so rulings at the hearing. So Chairman Harrington will preside as sort of our judge for the Civil Service Commission proceeding. And he'll decide questions on pleadings and on whether evidence is admissible or not. So
with a lot of conferring with our attorney.
I'll be around, and we may confer from time to time, yes. So as the hearing goes, the city carries the burden. They have to show by preponderance of the evidence that the employee committed a rule violation for which he was disciplined. It's just like, your standard trials you've seen on TV, basically. We're going to start out with an opening statement. We go first, and then the employee's lawyer will give an opening statement after that. That's just an introduction to the case. That's the case from their point of view. It's not evidence, and it's not to be taken as evidence. They're just kind of giving you how they plan to present their case. So that's, and they can tell you what they do anticipate the testimony will be or the proof will be. They can also give us stipulations of fact, which means a stipulation is a fact that's basically agreed or stipulated on. So we both agree that this person received their termination letter on this date. That's probably pretty non-controversial. We can go ahead and establish that and get that out of the way, and then we don't have to present proof on that. We can take you, or we, when I say we, you can take it with you to make the decision and consider that just like you would any other fact that was proved during the course of the trial. And you can, if they're provided before the hearing, you can read those stipulations, and it can cut down on the hearing time. I don't know whether we will end up with stipulated facts in this case or not, but it can be a very nice, efficient mechanism if it works out. So the rule in any trial, like the trials that I do down in our district court, either party can invoke the rule, and that means that the only witness present is the one that's testifying. All other anticipated witnesses have to be out of the room so that their testimony is not influenced by the testimony that's already been given. So, and that's pretty typical in most of my cases downstairs. We'll see the rule invoked. So I would anticipate that the witnesses will go to another room, and then the chair will instruct them not to discuss their testimony until they have been excused. Because sometimes witnesses are, the parties want them to still be available, so they may get sent back even after they've testified and possibly recalled. So we don't want them talking about their testimony in that situation. All right, so the city's going to present its case first, and the city's lawyer will call witnesses and ask them questions, and that's called, the direct portion of the examination. After that, the employee's attorney gets to cross-examine those witnesses. Then kind of the third shot is the city's. Usually you have direct, cross, and then redirect. Sometimes in criminal cases we'll have recross, but usually it's three shots and that's it. That's pretty much what you get. You don't go back again after that unless there's some very particular issue that you want to address that just came up in the third round. And that's what I just said. I think I just got a little ahead of myself there. So after the city's case closes, the city will say that the city rests. And at that point, they will have called all their witnesses. They will have presented all of their exhibits that they want us to consider. Whatever evidence the city has should have been presented by that point. At that point, the employee begins presenting their case. They're going to call their own witnesses, and it'll go just in the exact same manner. And when they're finished, then they will say that their side rests. I usually see this a lot, but after the employee side rests, it is a possible procedure for the city to have some rebuttal. So anything that any employees that the city calls at that point, or any evidence that they present after the employee has rested, should be very focused and limited to what came out in the employee's case, and that they were not able to address just through cross-examination. So there's a good chance we may not have that. There may not be city rebuttal after the employee rests. All right, then after that we have closing arguments, and closing arguments are not really that different than opening statements. They're kind of a summary of what the evidence has been, and the attorneys can kind of draw you to inferences that you can make from the evidence that was presented. The city goes first, and then the employee's lawyer goes after they go. Occasionally, the city might be allowed to address things that were brought out on the employees in the employee's closing argument as well. So, just like you've seen in all the shows, there are objections to evidence. Two of the most typical would be hearsay or relevance. If we get into the fact that the employee was the employee of the month in 2019 in the month of January, that's probably not relevant to whether or not they committed a rule violation and the termination or suspension or whatever happened was justified. So that might be an example of something where an attorney might object based on relevance.
And you will make those calls as we proceed.
You will make those calls as we proceed. You can ask for consultation.
Maybe a lot of that.
So if an objection is made and the chair finds that that is a valid objection, then they will sustain that objection, and you will disregard whatever evidence you may have heard that was in violation of a rule of evidence. So if it's hearsay and he sustains that it's hearsay, you need to disregard any hearsay that's inadmissible or any information that comes in that's not relevant to the case at hand. If they do not find it to be a valid objection, then the chair says overruled, and then you go ahead and continue with the presentation of evidence, and you do give due regard to whatever's been introduced. There may be, like, and we mentions here, particular documents. If a document is objected to and the chair sustains that objection, then you wouldn't consider that document in making your decision.
Was on having the documents and everything embedded already between the two attorneys, and they've agreed or stipulated or?
So during the course of discovery, they will exchange documents, or they will, request each other's documents and those kinds of things. But it is still possible that they will not have stipulated as to the admissibility of certain documents. And if they don't stipulate as to admissibility, then the chair gets to make that decision on whether or not it is admissible if one of them objects to it. Hopefully, most things will be stipulated to, but
Very hopefully.
if not, we'll figure it out as we go.
Will we be given those documents, or copies of those documents?
So if they are going to introduce those documents, they will bring copies. Yeah. Just a little word about hearsay. The definition of hearsay is basically, it's an out-of-court statement not made by the witness, offered for the truth of the matter asserted. Hearsay is a very complicated concept because there are also a lot of exceptions to it. And one of those is an admission against interest or an admission of a party opponent. So if we're talking about the actual employee and the city's introducing evidence, and the city says the employee said, the witness says, the supervisor, whomever says the employee said blah, 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 then that may be an exception to the hearsay rule. Whereas, in a lot of cases, hearsay is not admissible. There are exceptions. Excited utterance can be an exception. Something that you just said when you're very emotional or you're warning somebody of something like that. There are a number of exceptions to the hearsay rule. But that's just kind of the basics of hearsay. Similar treatment evidence. So in employment cases, which this is the type of employment case, it's very typical for people to make claims of discrimination based on how other employees are treated. So it could be that, the employee argues that another employee had a very similar rule violation and they were not terminated, or they were suspended instead, or something like that. Similar treatment evidence is very specific because it should be, they need to be similarly situated in all relevant respects. So they need to have committed the same or a comparable rule violation, and that's going to be a situation where the chair is going to have to make a determination of whether that's relevant. And to do that, you're going to be looking at everything being almost exactly the same in both situations. Generally, you're going to want the commission to be dealing with this situation and not bringing up, everything that's ever happened in the past, because seldom is it going to be that everything was exactly the same. It was the same supervisor, it was the same infraction, it was the same, the employee had the same disciplinary record. It's going to be rare that everything is going to be similarly situated. And this is, there's just some case law on here that talks about similarly situated employees. And it mentions a lot of things that I just said. Same supervisor, same standards, same conduct. All of those types of things would have to be the same for that really to be relevant and admissible. All right, so the burden of proof, we said, is on the city. And that doesn't necessarily mean that in the preponderance of the evidence is not always who has the most witnesses or who has the most documents. It should be, how does the evidence itself stack up as far as whether there was a rule violation and whether it was an appropriate discipline based on the rule violations that are alleged. and the decision should be based on what the evidence that is presented and that is admitted through the testimony, through the documents, whatever evidence we received during the course of that trial. Again, sympathy and prejudice are not appropriate. We just, we have to consider what evidence is brought in. All right, so once the commission retires to its executive session to consider its decision, you're going to weigh the evidence that both parties have given to you and determine whether the city met its burden. And that's by proving by the preponderance of the evidence that the employee committed the violation and was punished appropriately. All right, so the preponderance of the evidence is more likely true than not true. So it's considering all of the evidence as a whole and deciding what evidence is more believable, more credible, and if on any issue you think the evidence is equally balanced, you can't find that the issue's been proved. You have to weigh it and decide, is there more evidence that this violation was actually committed? Is there more evidence that this violation was appropriately punished? So it's a little different standard than like a criminal case. We have to prove beyond a reasonable doubt. Okay, so this is a different standard than that. The preponderance of the evidence is more likely true than not true. All right, so we know you guys go into executive session from time to time, and it is for considering employment, appointment, promotion, demotion, disciplining, resignation, those types of decisions. And there are very limited people that can be present for an executive session, and your attorney cannot come with you. So for those discussions, I cannot attend. So once you reach a decision in executive session, you will reconvene in a public session and present your vote on you'll vote publicly on the decision. And your decision is not legal or valid unless we have that public meeting in which that vote is made publicly. Decisions made by the majority. The chairman does vote, and the Arkansas Code states that the chairman is to vote as well. So if it's finally determined that there was a wrongful discharge or reduction in rank or compensation, then that employee will be given basically judgment against the city, and they are entitled to be compensated for whatever wages were lost during that time, but we do take into consideration any remuneration, I'm not good with that word, that they've received from other sources. So that can be kind of mitigation, kind of offset for whatever losses they've had. All right, so when you get ready to have the public meeting for the public vote, then you need a motion by a member to either uphold the city or overturn the city's decision, or if you want to modify the city's decision, you say, we're going to change it and it's not going to be a 5-day suspension, it's going to be a 3-day suspension, or whatever you're going to do. If you're going to make a modification to it, then there'll need to be a motion to take the action that you're going to take. Just like usual, there's a second, then we take a vote. Then either of the parties that lose can appeal. They can appeal it to the Pulaski County Circuit Court. We do have, I don't remember if this is in here or not, we may get to it later, but a court reporter is scheduled because in these instances we do have to have a transcript. So we have scheduled the court reporter to be here on that day. Any other documents as well will become part of that record. Any documentary evidence or documents that the order that the commission generates, if there's an appeal, will be included in the record as well. As far as what's included in our decision, it's generally going to be pretty simple. Either, we find by the preponderance of the evidence that the city showed there was a violation of these rules and that the punishment was justified, or we find that it was not there was no violation, or it was the appropriate was too severe, or something along those lines. As far as recommendations to the department head, the commission is somewhat limited as far as our ordinances do specify that the commission's not to become like a super personnel board and not interfere with the day-to-day operations of what the chiefs decide for their department. I guess, anybody's always free to give anybody advice, but they don't necessarily have to accept it. Another item is ex parte communications. So once we have a case pending like this, even, once we know anything about it or it's likely to happen or anything like that, ex parte communications are not appropriate. So neither side should be discussing with any of the commissioners facts related to their case, what happened, anything that could prejudice that decision. So we're going to decline, of course, any communications along those lines. There are, concerns over rights violations under Section 1983. So, of course, we would want to not engage in any of that kind of conduct. All right, so if there is going to be an appeal of our decision, there are 30 days in which to file a notice of appeal. Then we get prepared a written order with the decision, which everybody will approve. The transcript is prepared. The city pays basically the show-up fee for the court reporter, but if a transcript's actually requested and there are additional costs, then the party that's appealing pays those costs. And all of those items become part of the record that's sent up for consideration. So if it goes to the circuit court reviews the commission's decision on the record, and they can have additional testimony, but they're not going to cover the same things that were already covered in our trial here. So it is important that we, do it correctly and make a good record for them. So yeah, they can consider additional evidence if it's competent and admissible, but they're not just going to, accept cumulative evidence that's just kind of a waste of time. And these appeals can even go to the Supreme Court of Arkansas. If somebody wants to, they can appeal all the way up to the high court.
We've got one right now, I just saw the other day.
Oh, really?
Starks, is that his name?
Huh.
They had appealed to the circuit court, and now they're being appealed to one of the appeals courts.
All right.
I didn't know you could take that next step.
Yep.
Is it an error of fact or error of law that's appealable, or they just don't like that decision? Do they still have to come up with a reason for the appeal?
They would have have to have a reason for the appeal. Generally, it would be that maybe evidence was admitted that should not have been, or there was some kind of precedent already set that it was in violation of that precedent that exists in Arkansas case law already. But yeah, they would need to at least have some basis for finding or for believing that the decision was in error.
And the evidence, whether it's admissible or not, is Chairman Harrington's call. If for them to appeal that, would have to be an abuse of his.
Right, and it might be that the circuit court, in looking at the record, if they found that we admitted evidence that should not have been admitted, they also can choose to disregard that. So it would be an appeal of the circuit court decision.
So as I understand it, the commission can find one of three ways. We can find that the chief was acted appropriately and the punishment is correct. We can find that the chief did not act appropriately and the punishment is totally incorrect, or we can find that the chief acted appropriately, but we can lessen the punishment. Is
Right.
that correct?
You can modify it.
Modify it.
Mhm.
We cannot make it worse, though, can we?
No, I don't believe so.
So we can lessen.
That's a good
Those are our
question.
three
That is a
choices.
good question. I have not had that come.
Well,
Anybody
in
want
this
to do
case,
that?
yeah.
But yeah, in this case, yeah, there's not going to be
But
anything
there's-
worse you can do.
Every case is not that way.
Sure, yeah. If it were, a 3-day suspension and you determined it should have been 5, that might be a possibility.
So that's why we don't know anything about the case. We don't get to know any of it until the evidence is presented.
Correct, because you want to be impartial at that time and just consider whatever is admitted appropriately and whatever is admissible.
Is there any monetary element of damages to be considered, or just the decision?
Well, if you find that the decision was inappropriate and there are lost wages as a result of that, then the employee can be entitled to back pay, but again, with mitigation, like we talked about. So if they've received unemployment compensation, if they've had another job, whatever they've done in the meantime would mitigate that amount of back pay that they might be entitled to.
Would that be an element for us to decide in this form, or is that after we've made our decision, it goes back to the city to make that call?
That's a good question. I think once you've made the decision, there would have to be some calculations, but it might come back to you. So I'd have to research that.
Question.
Yeah.
Any other questions? This is
About how long do you think the hearing will take?
I
As long as it needs to.
could not even venture a guess. This is a fact pattern where there are a number of witnesses involved, and that's pretty much all I can tell you. And so, with a larger number of witnesses, it's just gonna take a little bit longer.
This is where it kind of all gets real, y'all. I mean, you're sitting here with somebody's career in your hands. It's a very serious matter, and certainly to that person, but to the city as well. But all this other stuff we do in here, thank goodness we don't have appeals all that often. Well, I've been here forever, and I've had that one case with two people, but the same case, and this will be my second. So thank goodness it does not happen that often, but it's serious business when it does. And I would request that you take it seriously and base your whatever judgment you come to base it on what you hear in this hearing. Don't know what else you might have heard. It's immaterial. The only thing that matters is what is presented and what you decide meets the criteria of preponderance of evidence, and that's the only thing that matters. So we'll all show up in November and see where that goes.
Will it be held here?
Will be. It'll be here, and it's at 1 o'clock, so it's not our usual meeting time. We at least get a head start, and we don't start at 6 o'clock at night. We want to get done by midnight, so.
The other one I sat in on, it was two people, so it took longer. Same case, but I want to say we were in there 3 or 4 hours.
Yeah, that would not surprise me at all. I think that's probably a minimum.
It can take some time. It depends on how many witnesses people call.
Hey, we did make it in 30 minutes.
That's pretty good.
Yeah.
Any other questions concerning the procedures for the hearing?
I just need to make sure I have the right date. It's November 18th.
I believe that's correct. Let me double check.
1 o'clock. Have 1 to 2. You're saying it could take a little more.
I'm afraid it's going to be longer than 2,
That is
probably.
very wishful
I can't
thinking.
swear to it, but I would guess.
Oh,
It's not gonna happen on your lunch break.
I marked off the rest of my afternoon, so,
Don't work.
yeah.
No tennis that day.
Is that the 18th?
Yeah,
Correct.
and it was the 18th. Yeah.
I neglected something when we first met. I knew she was going to be here, and I should have given her an opportunity to introduce herself. This is Lisa, our generalist. HR generalist, I think is what HR director told me. And she was sitting in and
Jack of all trades.
introduce yourself, please.
Yeah, absolutely. Well, hi, my name is Leslie Lambert. I got married back in March, so I'm still used to saying my maiden name. So I have to think for a second, whoa, what is my last name now? Doreen is out on vacation. She is currently enjoying herself out in the ocean. So she's living it up right now. So I am sitting in for her, but I'm taking good notes, and I hope to report back to her. So, yeah.
Thank you. Welcome aboard.
Yes.
Any additional comments or business? If not, I will entertain the motion to adjourn.
I'll make that motion.
Have a motion to adjourn. Do I hear a second?
A second.
Any discussion? All in favor say yes.
Yes.
Any opposed, no. Motion carries. We are adjourned.